Hi, my name is Akiva Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues, and today we're going to continue our video series designed to educate and inform the public, so please subscribe to our channel. A lot of the information that I use in producing these videos comes really from the viewing audience and the questions that we get from people, from clients, from people who reach out to us and say, hey, I don't understand this, or I'd like to know a little about this. That's what I mean when I say that we're providing education and information. So today I want to talk about a question that came up about jointly owned property in a divorce. What happens to it? You got to understand something about a divorce. There's something that's very unique about divorce as it relates to property ownership. Outside the context of a marriage, when we want to look at a home, let's say, and we want to determine the title, the ownership of the home, we're going to look to title documents to determine whose name is on there. So you may have a property and it may be in your name. You might have a lot of relationships going on in your life. You may have very important relationships going on in your life. You may have an employer-employee relationship going on. You may have relationships with children. You may have relationships with other relatives, people that you recreate with. You may have teammates on the baseball team that you play on. You may have all these sorts of relationships. But in the eyes of the law, none of those relationships impact the ownership of that property. If it's in your name and your name alone, even though you have working for the same guy, just you and that guy for 20 years, guess what? Close as that person may be to you, they don't have an ownership interest in your property. The marital relationship is truly unique in that regard. In order to have an interest in property, your name's got to be on the title. So if you're not married, it doesn't matter what your relationships are. If yours is the only name on the title, that means you own that property to the exclusion of all others. Once you are married, it no longer makes a difference whose name was put on the title. If you are married and you buy a home and it happens that the title is put in the name of your wife because she's the only one working. So when they did the mortgage, they did it in her name. And when they did the title, they did it like the mortgage, it's in her name alone. You know what? As far as the divorce court is concerned, should there be a divorce in that scenario, it's as if your name was on that property. We don't look at what's on the title, we look at the when question. When was the thing acquired? If it's acquired during the marriage, it is considered marital property. So it doesn't matter if the title is held jointly or singularly. Either way, it's marital. So the court looks at it as if both names are on that title, even if only one name is on. So when we're asked the question, well, what happens to jointly held property? If it's marital, that is to say, if it's property that was purchased during the marriage, it doesn't matter in whose name it is. Jointly or singularly, it's still divided up as an asset. Now, what happens if Joe Smith and John Smith buy a house together and it's in both names, and then 2 years later they get married? What happens to that? Well, in that situation, really, the status remains the same. It was joint before. It's joint now, so even though it belonged halfies to both of them before the marriage, now they got married 2 years later, and then later on they get divorced. What happens to that? It's the same as before. It was in both names before, it's owned by both, it's still owned by both, and the fact that they later on got married doesn't increase or decrease the ownership interest in the property. If you have any questions about your property, reach out, of course, and we'll be glad to help you out.